Good evening and welcome with another episode of Law and Order, where we discuss legal issues and solutions that we can give to your legal problems. So we were discussing about banking with the last week's episode, and now as a continuation for that episode we are going to discuss further on that particular topic. So today also we have with us attorney at law Mr. Thusitha Ediruvira, Chief Legal Advisor and Head of Legal Recovery of a leading private bank. Good evening to you, sir.
Good evening, Charita.
Right, and thank you very much for joining with us with today's episode as well. So we were discussing about banking and loans simply as a lending institution, how banks perform towards the customer, giving their prominence to what they need, giving the money for the essential things that they need to recover or they need to build up. So simply when it comes to loans, we discussed a complete idea, a complete outline of the facts, and we came to interest rates as well. So simply, if we give something, suppose that I'm taking something from you, so I need to repay that thing. So the banks follow the same procedure. So what is the background with regard to repayment?
Let me first say from a bank's point of view. Now, how does a bank has to look at about a customer, right? The most important thing is to retain the customer. In today's context, we have marketing, right? And we have to have litigation also, applicability of the law. But what matters is there should be a blend of this. Unlike in the past, where we go for hardcore recovery. You can't go now like that.
Right.
Because its competition is such. Customers sometimes tend to demand that if you don't cater to my requirement, I will go to another bank. So from marketing aspect, because of that, the bank officer has to cater to the customer's requirement and to the customer's satisfaction. At the same time, when it comes to lending, one has to be very careful, as I told you earlier, that the moment you part of something belonging to you from your possession or custody, until you get it back, you are exposed to a risk. So how do you mitigate the risk, or how do you reduce the risk, is the fact that as a bank officer, especially who is involved in credits and recoveries, have to be aware and mindful. So when it comes to lending, right, other than giving the money to the customer of what he has requested and where the bank has agreed, bank has to ensure that in future, that if the payments that does not come as agreed by the customer, is the bank ready or prepared, or how to recover it, or how they are going to get it back? Because they have one fact, that they have to always serve their depositors. So to serve their depositors, what they have lent, they must get it back. That is very important.
Very important. So as you said, like Department of Marketing and like retaining the customer, one of the most essential points discussed here. So basically moving on those things as well. So to retain the customer and to give prominence to, like, sometimes if I'm taking something from you, I might have a reasonable thing to say that I can't pay it right now. So somehow, so to ensure the rights of the depositors, banks have to somehow recover, but from the customer's side, what they can negotiate. So is there anything that we can negotiate as a customer from the bank to go in with some sort of another structure that we can pay?
Yes, basically when a facility is granted to a customer, you enter into a contract.
Right.
In banking terms, you call that an offer letter, right, where the authorized officer of a bank signs, as well as the customer agreeing for those terms and conditions signs it.
Right.
So in this particular offer letter, giving details of the facility that he is going to obtain, it states about the purpose, it states about the collateral, it states about the interest amount, the percentage, and it says how the repayment program.
Right.
That's the most important thing. So that you work out depending on the 3 C's of what I told you: the capacity, the ability of and the willingness of the customer, how you are going to stretch out the loan.
Right.
Whether it's 1 year, 2 years, 18 months, 36 months, likewise. So you should have flexibility there, right? Banks have their own guidelines saying if it's a personal loan, we can go up to maximum of 5 years, we say. If it's a housing loan, let's go up to 20 years, we say. Likewise, you have it. But depending on the customer's ability and the capacity of the repayment, you stretch out and give him a repayment plan. So the customer agrees to that. So then two parties come into a contract, right? So once you come into a contract, it has a legal obligation. So in simple terms, you say a girl and a boy, as long as they associate, there is no issue. But the moment they get married, what is marriage? A marriage contract. You have a legal obligation. You just can't leave that person off. Right? You may have to pay compensation, you have to go through a court procedure. So the same, I just told you in your personal life. So the same principle applies between a borrower and a bank. He has obligation. On that, so he has a commitment to pay. So in addition to the offer letter, there are other documents you call. What is just accepting or acknowledging the debt, you sign a receipt. Then you have credit instructions where the bank originates a letter giving the customer, as if the customer is addressing and giving it to the bank, instructions to credit what the loan is disbursed to an account of a customer. From that only the customer can withdraw and take it. So that is ample proof, or in legal terms you call documentary evidence that the facility is given, which shows that he has benefited from that facility. So that is called the letter regarding proceeds. Then as I told you, you get the security. Maybe depending, there are about 8 or 10 types of securities, but depending on the requirements, you apply what the security is. Maybe a DPN, maybe a personal guarantee. Like maybe a cashback sometimes. What do you mean by cashback? If an existing customer who has a good deposit base, but still, since he is doing business, maybe for various and obvious reasons, he wants to take a loan, right, to get tax concessions, tax rebates, other concessions and various things like that. He may go for a loan, but you can ask him to keep his deposit base as security. So then what you take the security as letter of set off, where he renounces his rights and gives his consent if he defaults as agreed by the offer letter or the contract documents in the repayment. The bank can withdraw his deposit and set off against the loan.
Individual set off means?
Individual set off. Individual set off. Maybe on a fixed deposit you can take a set off. Maybe on a savings account you can take a set off. Right? And what the bank does is, if you have a savings account, you place a lien for that amount. Now, when you take a set off, it need not be, it can be confined or limited to a particular account. Say in your savings account, you have 10 million, but the loan you take is 2 million. So you can limit your set off to 2 million and place a lien for 2 million. So up to 2 million, he can't withdraw it till he settles the loan. Other 8 million, he can take it if he wants. But once he settles the loan, the lien will be lifted. Otherwise, if there's a default on the part of the customer, the bank can recover it. The customer can't make any allegation or point fingers at the bank that you arbitrarily took his cash or deposit, because he has signed a set off and renounced his rights on that. Then, as I told you, you go further. Movable mortgages, it could be stocks, it could be machinery, it could be vehicles, it could be any other equipment and things like that. Then the most stable or the secured mortgage will be the immovable mortgage. It could be land and building. So that is how you secure your loan, basically.
So when it comes to mortgage, like it's a currently widely discussed area, I think, according to my opinion, basically, like mortgages are more frequent, is it?
Yes, because the banks always insist on the customer, depending on the risk factor that they evaluate from the KYC evaluation, as well as from his background, or depending on the risk factor of the customer's repayment capacity, and maybe depending on his business, or depending on his employment. Say if you are giving a facility to a pilot or to armed forces, You have to be more careful than you are giving it to any other, say a director of a company or something like that. Those issues also matters, applies. And at the same time, it applies on the nature of the business of yours. So maybe agricultural, cultivation, paddy. Now what is called pledge loans, we give it, right? But it's always at a high risk, no? Depending on the weather conditions, depending on floods, depending on other economic factors, depending on the political issues, right?
But
natural disasters.
But still the bank helps with
bank helps. So, but considering those factors, they decide what is the security they are going to take. So, but if you take immovable property as security, the bank is little bit relieved. You know, it's easy to recover it. It's easy to convert into liquidity. That one, because if you take stocks, sometimes if it's a rotating stock, it may not be available at the time of a default. If it's machinery, it may get corroded and the values may depreciate. But as you all know, the values of the land or the immovable property and the buildings will always appreciate. The market will appreciate because of that.
Right. So simply, so like if I'm the customer, I've obtained a loan from the bank, still I'm willing to pay, but at the moment I'm unable to pay my loan. So like restructuring or rescheduling, there are certain terms associated with banking. So can you just explain a little bit on those?
All that applies when it comes to a default. As long as you obtain a loan and you pay it smoothly as agreed and undertaken by your contract document, there is no issue. But it has been observed, it has been the practice that where the bank sometimes faces the borrowers default. Sometimes it could be defaulters also, they categorize willful defaulters and other defaulters which they are beyond their, or which call innocent defaulters which is beyond their control. That may be, as I told you, it can apply due to various factors, right, that defaults. So then what the banks does is mainly they do supervision. If they feel, now that in banks you get departments, divisions, we have to monitor these loans. From a housing loan to a personal loan to a commercial loan, monitoring is very important. Whether the customer uses or that particular loan to the objective that he has taken. Otherwise, if you say go and take a commercial loan, and if you try to send your child overseas for education, you will definitely crash. If you take commercial loan, your interest rate is high, so you must have earning for that to pay it. Likewise. So in this supervision, the banks will always advise the customers. They will say do it like this. They will say don't invest in these areas. They will say now in future these things you can anticipate, avoid those things, like that. So first thing will be the supervision, and try to help the customer at the initial stage of default to come out of that and to regularize it again. That's the most important thing. Then what is called, the next step is they do the revival of it. So revival can be divided in two categories, what is called restructuring, one, and rescheduling.
Right.
So rescheduling is something where on existing loan, sometimes they might say, right, we will extend the time period, right? We will give you some sort of concession, maybe a moratorium.
Like we heard it recently with this COVID-19
Yes, COVID-19, but even before that.
Before that it was
the
there.
Banks have been giving capital moratoriums, interest moratoriums, on both they give moratorium, capital and interest, both they give moratoriums. Likewise, you go on. Either interest rebates, moratoriums, extension of time, right? Sometimes maybe further funds, like a temporary loan to resolve this. So those are all called reschedulements. You reschedule it.
Right. So right. For a practical example coming on to that, I've obtained a loan. My monthly installment is 10,000 rupees. So I'm a good customer. I'm going to pay it regularly. Regularly means like without any due, I'm going to pay it to the bank. So this month I'm unable to pay. So I'm telling the bank, next month I will pay both the installments. Likewise, there are some irregularities since like 6 or 7 months of time period. So what will the bank do? Yes, Charita, it's a very important question, and this is a common occurrence with defaulters, I must tell you. Because just think for a moment, if you can't pay the this month's installment, how are you going to pay the this month's and the next month's installment together in the next month?
Likewise, how can you go 3-4 months if you get accumulation? How are you going to pay? You can't. So the bank officer has to be aware, cautious about that. Whether the particular customer, although he gives an undertaking, verbally or even in writing, whether he can pay it. So if he feels, the first instance, yes, he gives the customer an opportunity. Say maybe for 6 months, because under central bank also there is for 60 days, 90 days, you categorize it. They go on categorizing it at different slabs. So on that they give it. So, but if the bank officer feels or the customer feels, both of them feels that they are unable to still fulfill their obligation or the undertaking that they have given is, next option as I told you is either rescheduling it or restructuring. I couldn't explain earlier the restructuring. I told you what is rescheduling. Restructuring is you look at the loan from a completely different angle. Say if it's a project loans maybe, commercial loans, and you convert that loan thereafter into a more flexible manner, or in an affordable manner where the customer can pay, restructure it. So there's a subtle difference between rescheduling and restructuring. Rescheduling is same thing, you go on asking them to give them new terms and new interest rebates and things like go on. But restructuring is you complete now, especially these days. What's going on is people were affected due to COVID, their businesses were affected. So more than reschedulements, they go on restructuring the loans, so that it will not go to NPA. NPA is non-performing advances. Because non-performing advances is something which directly affects the bottom line or the losses of the bank. So even when it's in NPA, when you reschedule it, still it's in NPA. But with the restructuring, you can take it out from NPA and put it to the current section.
Right. Okay, so there's a very important thing that we came to discuss about restructuring and rescheduling, and moving on to the final part of the discussion, and the most important thing, and I think you are most suitable to discuss about that, litigation.
Yes. Well, litigation is something where the bank keeps as the last resort. I told you earlier, competition is there. Retention of the customer is more important. So the moment you go to litigation, the relationship that existed between the bank and the customer may have splits. So the bank will always try to avoid litigation and to see and to recover it amicably as much as possible. But there should be a limit to that. Customers also must understand, from a bank's point of view, they are also under heavy pressure from their regulator, the central bank. At the same time, they are under heavy pressure from their depositors. They also demand for higher interest at certain categories. We know senior citizens ask for different interest, other depositors ask for another interest, like that it goes on. Depending on the products, the interest rate varies on deposits. So same way, on lending also, we have to be cautious, we have to be aware that we have to recover what we give. Then only a bank can run smoothly, because this is not once and for all lending. No, it's going on a rotation. It's a process that goes on. So as a last resort only, the bank decides on litigation. Right? And you will see that somewhere the banks, how did they go on litigation? By going to court. Now ours is basically in Sri Lanka, we have the Roman Dutch law, we go to court under litigation. So there we go to a civil court. The first place we go for litigation will be the district court. Right? So the district court, and now we have the commercial high court. Beyond that, it's on a province basis, but what is existing is only in the western province, and there is a slab for that. Beyond a certain limit only you can go to the commercial high court, otherwise you go to the district court. And the other way of recovery is, if the traditional way of recovery was where what you lent is you try to recover through the security. So when it comes to especially the mortgages, right, there was due to our legal system, there was a long delay in recoveries. So then the banks could not serve in a better way to the depositors because the recovery was delayed. So in order to avoid that or to overcome this situation, in 1990, the economies at that time, through the central bank, introduced new pieces of legislation. That is, they brought the main act that governs mortgages is called the Mortgage Act.
Mortgage Act.
They brought an amendment to the Mortgage Act, what is called Mortgage Act Amendment Act number 3 of 1990. Then for licensed commercial banks, they introduced what is called Debt Recovery Act number 2 of 1990.
Right.
And also they introduced what is called Recovery of Loans by Banks Act number 4 of 1990. Among the bankers, what is called Parati Act. Parati Act.
Right.
So that gives an opportunity for the banks without going to court or without taking customers to court for recoveries to enforce the mortgages that are given by them through a legislative procedure. Right? That very specifically states. But one has to understand, especially in a bank, it is a quasi-judicial or a semi-judicial procedure that has been given to the board of directors of a bank. If I summarize and tell you, to adopt a resolution, to publish the resolution, giving details of it, to auction the property by public auction, right, and to sell and recover the dues from the borrower.
Right. So that is the most important part when it comes to litigation. And so, like, as we are running out of time, we discussed banking, loans, and even repayment, and we came to discuss about litigation finally. So as a summary, summing up the entire discussion that we did about banking and loans and litigation, so what do you have to say?
Well, customers must always remember, although they are defaulters, and although the bank either takes them to court or even go under parat execution, still the banks will always welcome their settlements. Although you file a case, since there is no other alternative or option available, as I told you, as a last resort, taking so much of attempts to recover it out of court, they go for litigation. But in court also, the idea is not to go through a case. Although you file a case, at a particular point, you want to come for settlements and agree on settlements. Even if you go under parati execution and say banks auction the property, and if there are no buyers to purchase the property for the market price, the act itself gives provision for the bank to acquire the property and resell it at a private sale. Within that interim period, if the customer comes with a settlement, the act itself provides the bank cannot reject the settlement. And the banks don't reject the settlement. Banks don't want these lands, buildings. What they want is only in a simple form to recover their dues. So still at that stage, even after acquiring the properties under parat execution, when the customers comes with a settlement, they welcome the situation, they accept the settlement, and they release the property back.
Right.
So always the banks, from banks' point of view, although litigation is available, they are always willing to help the customers to improve their economic conditions and as a macro to improve the economic conditions of a country.
Right. Thank you very much, sir, for enlightening us about banking, loans, repayment, and finally coming into litigation, which is your topic. And thank you very much once again for joining with us with this episode of Law and Order. We have joined with Chief Legal Advisor and Head of Legal Recovery of a leading private bank, Attorney at Law Tusitha Ediravira. Thank you very much, sir, once again. And this is Law and Order.
Thank you very much, Charit, for inviting me for this very useful and important discussion.
Right. Thank you very much, sir. And this is Law and Order, a program that where we used to discuss legal issues and we can give solutions for your issues as well. Thank you very much for joining with us, and stay tuned for another episode of Law and Order. Stay tuned. Then, good night.